Today is not a day to celebrate, but the arrest of Richard M. Allen of Delphi on 2 counts of murder is sure a major step in leading to the conclusion of this long-term and complex investigation. Of this long-term and complex investigation. Of this long-term and complex investigation. Of this long-term and complex investigation.
What is up, guys? Welcome to the transparency. Let's take a look here. We got tons of production of documents. Again, welcome members, subscribers, moderators. Look at it right there in the Supreme Court of Indiana. This is Delphi Talk. Oh, Mom for Life. You do amazing work. Thank you so much for saying that. Appreciate that. Boom, boom, boom. I was actually doing a lot of work this afternoon with the Dr. Moore case. I had some interviews. This is the Indiana Supreme Court. We got the Attorney General's response. This came out yesterday. And then we have respondents' brief in opposition to realtors' verified petition for a writ of mandamus. So there you go. These are the 2 documents. You know, it's going to come down to the law. What's the law? Obviously, this case is the Delphi case is extremely complex, as they want to say. I think they made it more complex before the Idaho 4 case. This is the case that I was deep diving and started from the beginning. So my thoughts are that obviously everybody is innocent until proven guilty. I read and did a lot of deep diving on Baldwin and Rossi's 136 pages. So my thoughts are based on those pages, based on the fabrication, I believe, of the PCA. I believe that Richard Allen is looking more and more innocent than guilty. You know, not only should he be seen that way, but when you read those pages, you just see a very, very inept leadership and law enforcement and doing their job. So that's what you see. Again, just that PCA is just pathetic. But let's talk about these documents. Obviously, we've been talking, and Gull believes that she was getting rid of counsel, okay, that was not performing, and they gross negligence. And then obviously she believes, as we're going to turn it on over here, that I was eating sushi yesterday when I went through this. There you go. This is her argument. And the court has never issued to reinstate counsel, whereas here the trial court removed counsel based on the court's reasonable findings that counsel had engaged in multiple acts of gross negligence. compromising the accused's constitutional right to competent assistance of counsel. Okay. Well, I look at some key words there. This court has never issued. I have to do more homework to see if it's ever been, but they're using when they say where, as here, the trial court removed counsel based on the court's reasonable findings. So does that mean that this has never happened before? Or is it just that if something's reasonable, nothing's ever been overturned? So really take a look at that key phrase there, in my opinion. So contrary to Realtor's assertions, neither this court nor the United States Supreme Court has held that a trial court may remove an accused selected counsel in two circumstances only. And then right here, which is, these are the circumstances where counsel is not a member of the state bar, or two, counsel has an actual conflict of interest. Let's take a look at this. All petitions shall state facts showing clearly, again, keyword clearly, that the remedy by appeal will be. So this part about it is that you're going to be able to do all this on appeal. And this is my thought on appeals, man. If we can take care of something before we have to go to the fact of an appeal and post-conviction blows. Who wants to do anything in post-conviction? So I know, I'm telling you, no, you don't want to go through the appeals process when you don't have to. So both sides were citing cases, by the way. Number two. So their big point here, number one, was that Realtor's petition fails the mandatory procedural requirements for seeking a writ. Okay. Realtor does not have a clear and unquestioned right to have his counsel reinstated. Then bullet point number two here is the trial court did not violate Realtor's Sixth Amendment rights by removing Realtor's counsel. Well, they say that a criminal defendant's Sixth Amendment right to effective assistance of counsel outweighs his limited right to select counsel. This is our argument. The Sixth Amendment to the Constitution guarantees that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The essential aim of the amendment is to guarantee an effective advocate for each criminal defendant, rather than to ensure that a defendant will be inexorably represented by the lawyer whom he prefers. So you choosing, it says that you get to choose your attorney, but at the same time, it's not going to outweigh and we didn't violate it by us removing who you choose. That's who he's chosen. That's how I'm interpreting that. Respondent properly exercised her discretion to protect Realtor's Sixth Amendment right to effective assistance of counsel by removing Baldwin and Rossi. She is going to stand by the fact that what she did was for his benefit. I did this for you. I would do this for anybody that's in your position. At this court has explained the right to counsel in a criminal proceeding does not mean the defendant has an absolute right to be represented by counsel of his choosing. The appointment of proper counsel is within the discretion of the trial court and will be reviewed only for abuse of that discretion. Then the trial court, right here, is granted considerable discretion to remove counsel so that the trial court has the tools to preserve an accused's Sixth Amendment right to competent and effective assistance of counsel. So, hey, remember, we removed you and we removed your counsel because it was in your best interest, because they are incompetent. I have to do my job as the judge here, and you're not receiving competent leadership representation. All right. But what is she deeming that is not is incompetent? And this is where we're going to talk a lot about what she deems was not competent and negligent. Okay. So number one, right here, respondent acted well within her discretion to remove Baldwin and Rossi over realtors' objections. The record supports that the record, she's saying the record supports this, that the trial court could reasonably conclude Baldwin and Rossi committed multiple violations of the rules of professional conduct, compromised the realtor's defense, and that the totality of the circumstances demonstrated gross negligence and incompetence on the part of the defense team. And she's citing the supplement record, page 15. And now this are the three big things. Number one, Baldwin and Rossi failed to take reasonable steps to safeguard confidential case materials, including crime scene photos. See professional rule 1.6, professional conduct rule 1.15a. Baldwin's friend and former employee Mitch Westerman went into Baldwin's office conference room, reviewed confidential photos of the crime scene, took pictures of those photos, and shared them with at least one other unauthorized person. Exactly. You want to see incompetence? Look at this investigation, right? 100. So the photos that were leaked, you guys, to the public, which prompted the police to investigate. Well, last time I checked, the police really weren't the ones investigating. It was the district attorney who was up for 17 hours a day, wasn't sleeping. I've just never, I've just never heard of a DA. Come on, man. I haven't been prepping for trial because I've spent the past however many days investigating this leak. Well, why are you doing that? That's not your job. Sorry, buddy, but that's really not your job. Your investigators are supposed to be doing that. Your detectives, your police, right? Think about that. The DA, when is your DA doing your investigating? I mean, maybe I'm fucking backwards, because, and please, I want someone to come in here and be like, Lana, you're wrong. And I'll say, okay, if I'm wrong, I'm wrong, right? But shit, I'm the one that I've gone down to our prosecutor's office in Columbus and took my happy ass there with a binder full of stuff. And because you know what a police officer said to me when they came to my house? A police officer said to me, holy shit, you are one of the most organized people we've ever seen. You're actually going to do a way better job of probably talking and repping your case. So this is what we advise you to do. You're going to go down to the prosecutor's office and you're going to sit down and have a meeting with the prosecutor, and you're going to give them all of this, because that's going to expedite your case. I was like, well, don't you want to investigate? Are you going to investigate this? Well, what we do in the investigation stage is we gather all the evidence. And what you have right here in this binder is all the evidence. Like, you've done our job for us, basically. And I said, well, yeah, that's probably true. I did do your job. Do you want to check on the fact of what if this is all lies? Needless to say, I went down to the prosecutor's office and had a big old conversation back in the day with the prosecutor. And yeah, everything looked great. Everything was perfect. They're just not going to extradite people. You know what I mean? If they lived in the state, they would have had their asses, boom, these are crimes. Okay. And then the prosecutor just goes forward, but the prosecutor's not investigating, you guys. And the prosecutor is your DA. So Nick saying that he was investigating for hours and spending all this time up till 4 or 5 o'clock in the morning and writing emails. Well, you're just a fucking moron. Okay. That's what you chose to do with your time versus prepping for a murder trial. Then that's on you. But an individual with whom Westerman shared the confidential photos committed suicide the night after police questioned him. Well, what did police say to this person that committed suicide? Was there a body cam worn? Was there a body cam worn? Like, I mean, how do we? So what they're alluding to is that Westerman, I'm sorry, that the person that Westerman, gave this confidential photos to, that committed suicide, it's on Baldwin. Baldwin, you have not only managed to get yourself kicked off this case, but you are responsible for suicide. It's pretty crazy, right? It's pretty crazy, if you ask me. But that's what's being said if you read the documents. But I look at it as like, what did y'all say to him? Because he had the photos, he leaked the photos, okay? Until the cops came to speak with him, he was alive and well. The cops came and spoke with him, then he offed himself, right? Those are the facts. So what did the cops say? What were they threatening him with? But hey, this is on Baldwin, they're saying. Baldwin, you managed to get yourself kicked off of this, be a disgrace, and have basically a suicide underneath your belt. Rossi and Baldwin agreed to use Baldwin's conference room as home base. So since they agreed that this is where we're going to be doing, this is like our round table, man. This is our round table. We agreed that we're going to use Baldwin's, conference room as home base for confidential case material. As you will see, the records will reflect volume 1, page 214. Then here's my little notation. Rossi understood. This is a huge, in my opinion, this is speculation. Rossi understood that Westerman would regularly visit Baldwin's office and keyword there is and. They teach you this when you're taking the SATs and the ACTs, to pay attention to the words or and, either and. So the probability of this happening and that happening, okay? They teach you big keywords. And's a very, very important word. So not only did Rossi know that Westerman would regularly visit, which how the fuck would he know that? But he also, and that Baldwin would share with Westerman information about the case to obtain Westerman's feedback. So remember how everybody was saying, well, Rossi has nothing to do with what happened to Baldwin. So can Rossi continue on as counsel for Richard Allen? And, at the very least, that's not what he wants to do, but he had nothing to do with this leak. He, that's how he was laying it out, is that the worst comes to worst. How can I not represent the guy? But here they put in, boom, this is why you, Rossi, can't be representing this guy either, because you understood that Westerman would come and regularly visit Baldwin's office, and that Baldwin would share with Westerman information about the case to obtain Westerman's feedback because he was a consultant. Let me see that consulting contract. And what they're doing here is, before we get to this, see how before we get to this, all right, you have this volume 1, page 214, but they're saying that this is listed somewhere, that somewhere in some documents that they're saying that this exists to be able to prove this. Just saying. Because, I'm playing fair on both sides. Now, number 2. So number 1 was, hey, your guys' home base was violated. You guys were supposed to protect this material that was under a, what's it called? It wasn't, they were under a gag, but more importantly, they were under a protective order with the material. This order, it was a protection order, just like in the Idaho 4 case, all the material is under a protective order. You can't disseminate it. You can't put it out there. You can't give it, So they violated a protective order. And it's just like, wait, how did I violate a protective order? This person, whether I knew them or didn't know them, committed theft. They broke in, okay? They went into an area they were not supposed to go into, and they took things that were not theirs. That is theft, right? So what would, Rossi and Baldwin have to do? Like, I want to call the cops and file theft charges, right? Can I grab one of those waters over there? Yippee, hey, hi, oh, mother. Oh, I know where that's from. Hi, Mandy. So here it is, number 2. Baldwin emailed confidential work product to an unauthorized person, and Baldwin and Rossi failed to timely report the leak to the trial court or prosecutor. Now, this is back in the day in December. Okay, the leak of crime scene photos was not the first time that Realtors Council were involved in a leak of confidential case material. In my opinion, with a hi Mod Squad, everybody out there shopping. Now, I believe that they're putting so much weight on stuff that is not that big. Okay, but here we go. In December of 2022, Baldwin sent an email to a person named Brandon Woodhouse, a defendant in an unrelated criminal case, that contained an outline of the discovery materials the state had provided to Baldwin. It was because he was typing in BRA and he accidentally clicked because he was doing this, and I'm assuming quickly. Also, I'm wondering, and I hate to say this, was it Baldwin that actually did the emailing, or is he just covering for somebody that worked at the office that was sending an email to Rossi, and they accidentally clicked, because it was like you're typing in Brad, BRA. Look at, and you go BRA, you see? Brandon, Brad. So that's how that happened. And it contained this outline of the discovered materials. There was nothing in it that was just an outline. Okay, it wasn't material. Baldwin, okay, apparently intended to send the email to Rossi. There's where they're Baldwin and Rossi did not promptly notify the trial court or the prosecution of this leak. Well, I guess my question would be is, when did they notify them? What's proper? What's considered timely? Because the same could kind of maybe be said for the prosecution, who was, I don't know, investigating this crime scene leak and not even telling the courts, nor did they tell Baldwin and Rossi even that there was this leak. It was actually Rossi that brought it to the attention that there was, if you actually go in order. So that's number 2. Now we get to number 3, which is Baldwin and Rossi made extrajudicial statements that had substantial likelihood of materially prejudicing the case. Now, what I think is interesting is that this came before there was a gag order, but they're saying that Rossi and Baldwin knew that there was going to be a gag order potentially coming, and that they went ahead and did their speaking out before they could be gagged. I just think that that's what's the word I want to use? Smart. That's just, hey, I got this little gap of time here. You know what I mean? And when they're talking about extrajudicial statements, they make it a point to say, because you are literally screaming from the rooftops that your client is innocent, that's extrajudicial. Like, look at this. Look at this. Right here. It says, they included in their press release detailed extrajudicial statements about the case, along with other information that would not normally be revealed, and proclaimed realtors' innocence. Holy shit. When I saw this, I said to myself, well, what do you want somebody's attorney to say? Hey guys, my client's guilty. How is saying that your client is innocent? Yep. And, we've talked to Richard. he's innocent. He did not do this. Holy shitballs. You know what I mean? I think about that. You need to put your phone on ring when you look at your call log, and the last 17 calls are all missed calls. Oops. Sorry. Those of you trying to call. And proclaimed Wheeler's innocence. Holy shit, you guys. They should be reprimanded because they came out and said our client's innocent. I'm sorry, that is fucking crazy. Damn you. Why didn't you say he was guilty? How is that extrajudicial? Please, come on, man. Okay, Baldwin and Rossi did not limit their press release to information that Rule 3.6b expressly permits, nor did they confine the press release to information necessarily to mitigate adverse publicity under Rule 3.6c. Can I ask you guys a question? This is how I usually feel about stuff. In a relationship, when you tell somebody, like, why are you bringing up something that happened a year ago? Like, if that clearly was a problem, why didn't you say something then? This December of 2022, so a year ago, Baldwin and Rossi knew or should have known that the press release potentially, it does not say violated. Keyword there is potentially violated. Potentially violated. So you want to get, again, you have to pay attention to these keywords. Rossi and Baldwin should have known that the press release potentially violated. Okay, so it didn't, though. It potentially could have, but it didn't. So they know that. So if it potentially violated it, that doesn't mean that it violated it. It means, maybe it's walking, a fine line. We know that, but guess what? We believe that we're within our rights to do this, so we're going to go ahead and do it. They don't come out and say that Baldwin and Rossi should have known that it does violate, that it potentially violated. Moreover, at the time of the press release, Baldwin and Rossi knew that the state had filed a motion. So the state had filed the motion for a gag order. The state wanted a gag order. Well, okay, great. Who gives a shit? They filed a motion for a gag order. That does not mean that the gag order would be issued. Does that make sense? Like, because you filed a motion, motherfucker, doesn't mean that I'm not going to do something. Who gives a shit that you filed a motion? That does not mean that there was a gag order. That does not mean that there's going to be a gag order. You filed a motion. It doesn't mean shit. You know what? People file motions against me all the time. Sorry, but it doesn't mean dick. That's the facts. So the state files a motion, whippity shit, which was pending before the trial court. Again, whippity shit. There was no order. So this is what I call smart. Prior to issuing the press release, Baldwin and Rossi assured the trial court that they did not intend to try this case in the media. Okay? I can assure you that I'm not going to try this case in the media. That does not mean that I'm not going to talk to the media. Period. Baldwin and Rossi's decision to issue the press release prompted the trial court to issue the gag order. Awesome. Great. Period. End of story. No violation. Period. Like, we did what we did, and guess what? You said, you know what? I'm going to do what I'm going to do now, and then you gagged. Awesome. No violation here, though. You made your decision because there was a pending motion that you sided with. And now, it is pure, you're just saying this. There's no proof that if we don't put out that press release, that there's not going to be a gag order. There's no proof in that. But that's what you're trying to claim here now after the fact. So this is going to hold no weight, in my opinion. You're saying, well, guess what? The only reason why I filed that and did that gag order is because y'all did your press release that you did. Give me a break. That's what you're saying. There was going to be a gag order whether or not they wrote that or not. Okay, sit and spin. Baldwin and Rossi issued the press release knowing that the trial court would likely soon issue a gag order. Exactly. So that's why they wanted to go ahead and talk to the public. Again, nothing is wrong with that. That's exactly what you would do. What do you think the Gonsalveses did? What do you think everybody in Idaho was doing and the police when they wanted to put out the statement that Brian Kohlberg was wearing gloves and hiding his DNA when we arrested him and he was just dressed like fucking 4 gloves on? Let's just get all this shit out before there's going to be a gag order. So all of those people were what? Bill, how about Bill Thompson, everything that they did, all these interviews and saying all this stuff? I would send my kid there. Those are extrajudicial statements. How about you want to compare the same case? We'll go to the Delphi case. So for 5 to 6 years, the law enforcement agencies, to also include the families, you guys could say, and the prosecutor, you guys could say and do whatever the hell you wanted for 5 or 6 years, telling us whatever the hell you wanted, right? And the moment that there's an arrest, and now if Richard Allen wants to utilize the public, you pull the plug on that. Think about that. And remember, that's all that Rossi and Baldwin said, is that you use the public for 5 to 6 years to gather your tips and do this and do that, and you put out sketches and call us, and then you're just trickling out information, just little chunks, and wanting people to come forward. Like, that's what y'all did. And we say a couple sentences when there was not a gag order, and even if the fact that you were thinking about putting a gag order, I don't give a shit. I can say all this until you gag me. Go ahead, gag me. That's how that should be looked at. It's so funny though to see somebody in law write this. Baldwin and Rossi issued the press release knowing. How do you know? How are you going to write something that they did? That is speculation, argumentative, and bullshit. You don't know why the hell I did something. Our client was arrested and we have media all over the place, right? So I didn't have the media. Oh, hey, come to my office and let me have a sit down with you. No, the media was catching them outside of hearings. Give me a break. Number 4, Baldwin and Rossi provided false information to the trial court. Now, this is interesting because if we're going to say that Rossi and Baldwin provided false information to the trial court, then I want to know what the PCA is. The PCA is false information to a magistrate to obtain a search warrant and an arrest warrant for Richard Allen. Okay. So let's just let this sink in. If you're really going to write this here, then where can we write? Oh, wait, that's right. The Franks hearing that we're asking for, right? Baldwin and Rossi provided false information to the trial court. So you want to kick us off, disqualify us. So what are you going to do with the false information that law enforcement provided to obtain an arrest of Richard Allen? What are you going to do about that? Is it going to be tossed so Richard Allen gets to walk out the door? Is that what happens? Professional Conduct Rule 3.3a. So on or about June 20th, 2023, the trial court held a hearing on Realtor's motion to reconsider safekeeping order. This is because of the way that they were saying that Richard Allen was being housed. Okay. This is a guy that's innocent until proven guilty, and he is in a max prison. He's in max prison. Isn't that where he's at? Like, what? He should be in county, right? Moving on. At the hearing, the state presented evidence that clearly, in quotes, demonstrated the falsity of Realtor's claims. On July 19th, 2023, the trial court issued an order on the motion, finding that the evidence presented at the hearing did not support many of the allegations advanced by defendant's counsel. In fact, the evidence presented demonstrated the defendant is treated more favorably than other inmates housed. Wow, that's saying a lot. That's saying a lot about the way Indiana's working. Damn. As a result of these events, as a result of all these events, guys, the trial court became gravely concerned with realtors' rights to have competent, non-negligent representation. The record demonstrates that the trial court, based on the totality of the circumstances, could reasonably conclude that counsel's representation of realtor fell objectively short of the prevailing professional norms, and that counsel's defiant performance prejudiced the defense in violation of realtor's Sixth Amendment right to competent counsel. When I read this, you guys, I said, oh my God, how does any family divorce attorney, family law, how do any of them have jobs? Okay. You want to talk about if this is what gets you disqualified? Shit. I want to know how any family divorce attorney has a job, because all they do is file motions that are totally bullshit. Okay. So like, let's say that somebody is doing X, Y, and Z, abusing your kid, doing this, doing that, knowing that the evidence shows exactly the opposite. And what should happen to them for writing up false claims like that? Well, they do it every day. Nothing happens to them. They lie every fucking day to their clients, to the tribunal. All these family law lawyers do are fucking lie, and they're in some little cahooty pooty because, hey, guess what? We got to keep this thing going, get our clients to keep on going, because we just make more money. If this is settled in 2 days, we don't make any money. So those of you guys that are watching the Jared Bridegan, Shanna Gardner case, and that's one of the cases I'm covering, I have all 70 or 740, and I read them all last night. I read 736 pages last night. And it is everything from Jared Bridegan and Shanna Gardner's divorce, and how mainstream media is making it seem is that, oh my God, this was like, you're thinking 736 pages. Like, dude, I read it like that because it's all a bunch of fucking bullshit. Every other page is a signing page, and you know how they do. But when I get to cover that here, and I am tomorrow, wait till I tell you what I think about that, going back and forth with divorce stuff. And they think that, oh my God, it's going to be so damaging for Shanna Gardner. No, it's not. I read all 736 pages. I can tell you that nothing in there is damaging to Shanna Gardner. Nothing. But what I think is crazy is, did you know that Shanna Gardner and Jared Bridegan were getting a $8,700 stipend a month from Shanna Gardner's mom to live off of? And you know, they just pay their bills and whatever. And so I was like going back and like just like looking at everything, and you know, because Shanna Gardner's moms, they got ridiculous money, but it's like nobody was working in that household. Jared's in getting his master's. Shanna is, you know, I don't know. I think doing maybe like a YMCA class, raising the kids though, but they're just trust fund babies basically. They signed a prenup, but it's we'll talk about it tomorrow. Oh, thank you so much there. Kay Miller gifting, making everybody turn green in here. What a sweetheart. You the best. You the best, girl. She at it again. That's what I say. She at it again. So, yeah. But if this is of grave concern, then I think divorce attorneys in family law, literally, this is what they do every single day. Every single day they're making filings that are not true. Every single day. And it's like, okay, well, I want to disqualify, you know, and if this stands, then shit, I'm telling you what, I promise you, every single Ohio divorce attorney would not have a job. I don't know what to tell you, but I mean, and I have it actually in writing where I wrote and said, hey, let me know if you want to take your divorce attorney for malfeasance. Go look up what malfeasance is. Malfeasance, in case you don't know, I'll just really quickly tell you what it is. It's when you are abusing the system to not settle stuff out and continuing on when you can prove that they're doing that not in the best interest of their client, working on things that have no relevance, stuff like that. So, but what they do is, it's sick. When you're ever dating somebody and you're younger and someone tells you they want to be a family law attorney, fucking run. Because what it takes to do that to people, the type of people that are those type of lawyers, I'm sorry, that is a morale. That is a mindset that, whoo-wee. You want to talk about trusting? You want to talk about dirty. And it, but I'm telling you what, if you want to make money and you don't care about fucking people over, I think I should write a book and show you guys how to claim bankruptcy right before you have to pay your fucking attorney. That's what I think. Put them on the list. Moving on. Ways to fuck your attorney after they fuck you. Name of the book. So yes, let's see. The professional norms in Indiana. The professional norms in Indiana are violated when counsel fails to safeguard confidential case material, provides false information to the court, and makes extrajudicial statements that are likely to prejudice the case. So again, declaring that your client is innocent is extra judicial statements. I just cannot believe that. I mean, isn't that all that the Murdoch lawyers were doing out there, talking about how innocent? Everybody says that their client's innocent. Fuck, that's all that Jose Baez, Casey Anthony's innocent, Shanna Gardner's innocent, Aaron Hernandez is innocent. He just got 14 murder charges off the doctor here, Dr. Hustle. He's innocent. Well, found innocent. In respondents filing complaints against Baldwin and Rossi with the Disciplinary Commission Act would not have ensured the relator would receive competent representation throughout the remainder of the proceedings. That's the other thing, is that it was a conflict of interest when Rossi filed with the DOJ to, with the treatment and whatnot. Let's see. Now, the argument is that due process, this is the big part. We want to talk about law, we have to talk about due process, okay? And so when I was reading this, and I was really paying attention to what Rossi was saying, or not Rossi, but Baldwin was saying, because he was speechless, but he's like, I really think this is a due process thing. I really think this is a due process thing. You need to give us time to, you just have us here in this room and you're going to tell us all this stuff. And then you're basically saying it to us, either you quit and withdraw, or I'm about to disgrace you. And it's just like, this is not due process. This is not how our occupation works. Okay. And I think the frustration truly with Rossi and Baldwin is yeah, dude, we're lawyers and judges work together because this is the judicial system and we need to work on all, facets so that it's just one big working fuck fest. And what we're seeing right here is we're seeing a judge literally go after, their, judges were lawyers at some point. Just think about it. You're kind of messing with our lovely little circle that we have here. So for the judge to do this, and then for, Rossi and Baldwin to go right back at it, this is so unprecedented. They don't like to air their dirty laundry on how shitty they are. So here it is, though. The trial court afforded realtor adequate notice and an opportunity to be heard before removing his counsel. I disagree, but the way that they write this up, when you read this, it looks like they did, So this is how cool they are with words. And this is how they just leave out the stuff that they don't want to talk about and just make it look so good. So realtor argues that the removal proceedings should occur at a hearing where the defendant and his chosen counsel are provided notice and an opportunity to be heard on why the attorney-client relationship should be severed. Realtor cites no Indiana rule, statute, or case requiring notice. And I thought that was interesting that they didn't cite anything like that. And maybe it was an oversight. Maybe that truly didn't happen. Who knows? Because they can just write whatever they want in these briefs. In any event, the record confirms that respondent provided realtor with ample notice that the trial court was considering disqualifying Baldwin and Rossi before October 19th. And you have to pay attention to the timeline. And the thing is that no, the state asked for the disqualification. Why would, and this was an informal phone call, okay? Like, this is a phone call. This isn't like in chambers. Like, they had a phone call, and where in emails where the state was like, we want them to be disqualified, and then she claims that, well, I'm leaning towards that. And remember, that's where Rossi said, how is that form? What do you mean on a phone call and an email? You say, oh, I'm leaning towards that. But like, what? Like this was all like ex parte, I feel like, communication, but it wasn't. It was like conference status, man. It seemed like it was ex parte, but it's not. It just seemed like it was like a status conference update. It was just so weird when you actually read this timeline. But that basically they were given their notice when that was happening, ample notice in her opinion, but zero due process. Yeah. So on October 11th, realtor wrote a letter. So this would be, this is when Richard Allen wrote a letter to respondent requesting that Baldwin and Rossi continue to represent him. This is the letter that after he found out about the leak, okay, he writes this letter. And he acknowledged that the prosecutor was seeking Baldwin and Rossi's disqualifications. On October 12th, 2023, Rossi wrote a letter to respondent, which is, court, arguing why he and Baldwin should not be disqualified. On the morning of October 19th, 2023, an attorney representing Baldwin filed a memorandum regarding possible disqualification sanctions. Realtor had adequate notice and opportunity to argue against respondent's disqualification of Baldwin and Rossi, meaning from October 12th to October 19th, get prepared so that way when you come up in this on October 19th, be prepared and you can argue it, which is what she is saying is that you're going to go out there instead of you withdrawing here inside chambers. We're going to go out there, and at that out there, that's when you're going to be able to argue this. But she had already made up her mind, so I don't know how you're going to sit here and say that we can argue something that when you're already and you already told us in there that either you withdraw in here or I'm writing, or I already have my written, here's my written up thing. Okay. So she's trying to, what she's doing right here in this paragraph is rewriting history. This is not what happened, but she's trying to rewrite history here, in my opinion, because this looks really good on paper. Like, yeah, wait, she did do the right thing. She gave them all this time. Yes, there you see, Mod Squad. There you go. Yes, that is proof that they were all aware that she was thinking about something, that something was brought to her attention, but she did not follow the proper processes to do anything about it. No motion, no hearing, no complaints filed. And how she tries to rewrite history here in this lovely paragraph is that, oh, if you wouldn't have withdrawn, you took away your opportunity when you withdrew. That's basically what she's saying here. She's saying right here, on the morning of October 19th, an attorney representing Baldwin did it. Then right here, Baldwin and Rossi also had the opportunity to proceed with the scheduled court hearing on October 19th, but chose to withdraw instead. You passed up on your opportunity to be heard. And it's just like, man, don't attorneys have a way of totally like, that's not what happened, honey. No, you threatened me. You threatened me. That's what happened. I didn't have an option. That's her argument, isn't it? No, that's not what's going to happen here. We're not going to go out in public and hurt our client's case by going out there in public and letting you run your mouth. Okay. That's just not what's going to happen here. But right there, I highlighted it and I said, this is what she's basically saying is Baldwin and Rossi also had the opportunity to proceed with the scheduled court hearing, but they chose to withdraw. At the October 31st, 2023 hearing, Baldwin and Rossi further argued against her disqualification after filing new appearances, and the trial court afforded them what? Like, let's see. Wait, what does it say? Afforded them what? Afforded them an opportunity to be heard. You guys, this is me giving you the floor to be heard for a couple minutes, but me knowing that I'm not going to do anything with what you say. Yeah, you gave me the opportunity to be heard on the record, including via Baldwin's counsel. The trial court afforded realtor adequate process. Look at that. Adequate process. What about due process? See that language there? Adequate process. Like, what why wouldn't they just say due process? Could you not write due process because it wasn't due process? But adequate. Well, I don't want adequate process. Just like, that's adequate representation. I just think this is interesting language when you really break it down. Realtor's request for this court to order respondent's disqualification fails because respondent has shown no bias or prejudice towards realtor. So what she's saying is that you have not shown the courts how I've at all have been biased towards the realtor, and that because you haven't done that, or your counsel, I have not prejudiced you, nor have I been biased towards you or your counsel, and you never put this anywhere, even in your motion, is what she's saying. So realtor's assertion that respondent must be disqualified because she removed realtor's former attorneys is flawed. First, Baldwin and Rossi no longer represent the realtor, and realtor does not assert that respondent has any personal bias or prejudices towards himself or his current counsel. That's what I was saying, that she was arguing that you never even bring this up. Second, on the merits, realtor presents no relevant facts supporting a realtor's assertion that respondent is biased or prejudiced against realtor's former counsel. Lana, can I press charges on myself for sexual harassment? I mean, I'm sure you can probably do anything you want. Depends on probably what jurisdiction you go to. In Delphi, sure. Go to Carroll County, sure thing. So, let's see. Right here. The law presumes a judge is unbiased and unprejudiced To overcome this presumption, so just like you're presumed innocent, a judge is presumed unbiased and unprejudiced. So they have the presumption of that. To overcome this presumption, realtor must demonstrate actual personal bias. And so that's what they're saying did not occur. Okay. An adverse ruling or finding by a trial judge, those are not sufficient reasons to believe that a judge has a personal bias or prejudice. How long does it take for you to decide that you're going to have a Franks hearing? Now, she claimed that there was 1,500 pages in that Franks hearing based on exhibits as well. It was 1,500 pages. Is that accurate? Because we only have 136 pages. So you're saying that, what is up, Nancy? Hi, Nancy. Nancy! So if that's true, you're saying that roughly speaking, 1,300 pages, let's just say, of exhibits and 136 pages was, of the motion. And then there was literally 1,300 pages worth of exhibits, because she says, well, I haven't even gone through that. I haven't even, it's 1,500 pages. Well, there's supposed to be a trial starting, sweetheart, in January 2024, January 8th, I believe. What do you mean you haven't gone through that? The fuck have you been doing? What else do you have on your plate that you should be doing? It seems like all of the internet, they see these documents come out and boom, or were you just consuming yourself with the investigation as well that you shouldn't have been? So Baldwin and Rossi no longer represent the realtor, and realtor alleges no bias towards himself or his current counsel. So respondent removed Baldwin and Rossi from representing realtor on October 31st. Now that's what's interesting, is that yes, they technically removed, but respondent appointed new counsel, which I believe that counsel is, and if it has not come out, that counsel is withdrawing. That's what I have in my works with my sources, is that the Allen County Scremin. God, if that was my last name, shit, man, I'd be pissed. What do we have over there? Any high noons? What do we have over there? Anything? Some Jameson? I have some Jameson. Let's have a little sip. But I was going to say, oh yeah. My sources have it that, Allen's counsel is withdrawing. Now think about this, because I'm going to bring this fact up as I think we're getting there. If I was Allen and I'm telling you, wait a second. That's great that you've been appointed my counsel. You have to ask me if I want you to put in file for a continuance. And I can't possibly imagine that Richard Allen was like, yeah, file a continuance. I'd have been like, no, you're not filing a continuance. Like, I want to go to court and have my trial in January. You know what I mean? Like, you can sit with Rossi and Baldwin and get caught up to speed and consult with them, even if they're not the appointed counsel. What they can't have any. I thought that she even said, yeah, you're going to work with them to get them and give them their things, and hopefully you would, talk with them. Okay, great. So my question is when his new appointed counsel went ahead and filed for a continuance, how does that happen if, in fact, Richard Allen was like, you have to ask me if we can do that? Like, I'm your daddy, right? You're my attorney. So I'm curious as why it has not been circulating yet. Because if I was Richard Allen, I'd be saying, wait a second, hold up. I never told my fucking attorneys that they could file for a continuance and that you guys can just go ahead and set this out. And in fact, I want my trial to be, in January. So I'm curious how, that's all, like, I would have a problem with it. If I was Richard Allen, I'd be saying, I'm your daddy and you're going to do as I say, or I'm going to be like the guy in Wisconsin and subject matter jurisdiction, and I'm going to just rep myself. And I'm going to have Rossi and Baldwin sit second chair. Is that legal? So here we go. Representative the council. The realtor is represented in this original action by Lehman, Kara. Realtor accuses the respondent of exhibiting bias or prejudice exclusively towards Baldwin and Rossi. Realtor never suggests that respondent is biased or prejudiced against realtor or his, what was it right here? Current counsel. Given that Baldwin and Rossi are no longer counsel of record, realtor's sweeping assertions that for all rulings going forward, the public will question the judge's impartiality. And then a new special judge must be appointed to restore the public's trust in the integrity of the judicial process amount to blind speculation. Well, your whole fucking motion is blind speculation, in my opinion, because you weren't in any of those rooms. You have no idea what took place. And the presumption of innocence for their client, and just like you want us to presume that this judge is just like fucking amazing, and the presumption of that they are not biased and they are not prejudicial. You also have to assume that, that Baldwin and Rossi, like they took an oath, have your hearing, have this hearing, put out the evidence that they did X, Y, and Z. And that's when Nick was like, yeah, we have our exhibits here. We're ready to go forward. And they're all like, wait a second, we didn't even know about this. And we're going to go up against the exhibits and not be able to defend ourselves properly. Like, who the fuck, what the hell is going on here? So cheers. But this shit looks good on paper, guys. I'm not going to lie. This looks good. This looks really good on paper because she's changing, history. Even if realtor fails to show that respondent has actual bias or prejudice against Baldwin and Rossi, even if Baldwin and Rossi still represented realtor, respondent has exhibited no actual bias or prejudice against them. You don't think what took place in the room is biased? You don't think that would be biased? Have you? Because then I need to ask this question. So, Judge Gull, it has been a practice of yours to bring in and haul in lawyers and sit them in your chambers and say, you're either going to withdraw or I'm going to publicly shame you. So that must be a normal practice of yours. If you're saying that what took place or that realtor fails to show that respondent has actual bias or prejudice against Baldwin and Rossi, well, I believe that the day that they had that meeting and how she conducted herself in that meeting, if you're saying that you've done that and that's how you conduct yourself, then yeah, it wouldn't be prejudice or biased, right? But you're going to have to admit that you've brought in lawyers in the field that you're supposed to be, having all this respect and, we work together and we don't do this type of stuff to our equals, So you're going to have to say that you brought in lawyers before and that you've done that. Otherwise, I believe that right there is the biased and the prejudicial, that you prejudice them on not having due process, right? I mean, or she's going to have to say, oh, no, man, I do that shit all the time. I bring people in there all the time and I say, listen, I'm going to threaten you here. Either you're going to go ahead and withdraw or I'm going to own your ass. Right? She didn't want Allen in her chambers, another clear sign of bias. I don't think the DOJ would want me to have him in there. So that was my thought on that. Realtor offers a scant 2 sentences to support his assertions. Offers 2 sentences. That respondent has exhibited bias or prejudice. So I guess the Frank's motion was too much when we gave you 1,500 pages. Now when we only do 2 sentences because we know that you can't, work that quickly, now it's not enough. That's what I would say, just to be a fucking bitch. Let's see what else we got here. Respondents finding that the counsel was grossly negligent and publicly proclaiming that she'd had grave concerns about the representation warrant respondents' disqualification. Further, these findings do not demonstrate actual personal bias. Again, I'm telling you what shows actual personal bias is you thinking that you could bring them in there and do what you did. That's where the bias comes in, because I want you to tell me when the fuck you've ever done that before. And so maybe they need to amend their, what they're saying, but that's where the bias comes in. That's where you personally came for me and Rossi, was in your chambers when you said that you have a statement prepared, but I don't want to have to go and do this. So if you withdraw, then I don't have to go and publicly shame you. And all I would want to say is, when have you ever given somebody that type of an ultimatum? And if you can say that you've never done that, then my opinion is that's not normal practice for you. And that, have you ever disqualified somebody before? What did you do when you disqualified somebody before? What was your process? So again, that's how I would. And again, I'm not a fucking lawyer, but that's just what my common sense tells me how I would try to attack that, like, part of it. Rather, she had concerns only about the representation of the realtor and his right to competent representation. Again, that's her opinion. So that's the other thing. That, how about this? How about when I go to the judge and I say, listen, I want a new attorney. This person is not representing me the way that I want them to. Or I want a new guardian ad litem because they fucking have lied. And here's the proof that they've lied. So what happens there? Well, the judge just doesn't say, oh, yep, that's it. You're going to have to show that shit, right? So here she's just saying, I'm deeming it that, and these are my things that I've seen, which in a high profile case, this has happened and it's just not them. There's been leaks for days. And so I'm curious how they're going to rule on this. I'm curious how they're going to rule on it. Respondents' legal findings regarding Baldwin and Rossi's representation are insufficient to overcome Indiana's law's presumption that respondent is unbiased. And see, Indiana's laws, it's going to come down to the law, right? And then they say that no, and I highlight it. The court should deny realtor's request to reinstate the trial date. Now they're making it a point like, hey, we're not going to reinstate this trial date either, right? Realtor requests this court to reinstate the January 2024 trial date. But realtor's counsel requested the trial continuance because counsel will not be ready to try the case in January. That's what I just said 10 minutes ago. And this is what and why I believe that his counsel is bye-bye. We're going to trial in January. And if you're telling me that you can't go to trial and represent me in January, then you're not going to represent me. So bye-bye. And I want new attorneys. So go and have them withdraw. So my point is that who gave those attorneys that were newly signed the okay to ask for the continuance and to set out this trial date? Because Richard Allen would have to say that he wants that. And I don't give a shit if you're going to sit here and tell me, well, no, Richard, I get that you want us to go. We're not going to be ready. Well, guess what? Either get ready or get the fuck off my case. Okay? I don't care if you have to be with Rossi and Baldwin morning and night. They already said they would work this pro bono. So they're going to sit and kick it with you every single day and they can consult with you. They're just going to give you all of their work because that's how I want to be represented. Everything that they were going to do, you're going to do, or you're going to get the fuck out of my face. Think about this. That's exactly, you don't think that Richard Allen was told exactly what to do and what to say by Rossi and Baldwin when he was still their attorneys? You don't think that Baldwin and Rossi had kind of some inkling when they spoke, when they saw and they said, well, we need to talk to our client on October 19th. So explain to me how you think Richard Allen does not have a say in, wait a second, back on up. My attorneys have already done all of this. They're going to give you everything. These are the questions that you're going to ask every single one of these witnesses who we are going to call. This is how we're doing it. And then they're going to still pump you information. They're going to sit in that courtroom every day. Okay. And they're going to be passing you notes. Okay. And this is who we still have to depose. This is what we're going to do. This is what we're going to do. And if you're not going to be my bitch, because I'm your daddy, and do as I say, then you're not going to represent me. So think about that. That's all he has to do and say. I'm ready to go to trial. And so if I'm ready to go to trial, my old attorneys were ready to go to trial, we're going to trial. And if you can't, and if you can't or won't do it, then you need to withdraw. And that's what I believe is going to happen. But for you, if I'm Richard Allen, I'm not sitting in prison, okay, for another year with these fucking Odinites. It's just not happening. Odinites. I'm not sitting in prison with these patch-wearing motherfuckers. I'm sorry, I'm just not. I want to have, when are we going to have my Frank's hearing? So, but this to me, as I was like, oh, here it is. And then she tries to say in this, it was Richard Allen's counsel that asked for the continuance, no, my counsel did not ask me about that. They just did that on their own. So I fired their asses. They're fired. So now I'm without counsel again, and I'm going to hire my own counsel, right? So then I want to know who's really good friends with Baldwin and Rossi. Who's really good friends with them? You got to have some lawyer friends, right? Well, fire your little Allen public defender, and Rossi and Baldwin's really two good friends, in my personal opinion, should step up to the plate and take one for the team and rep Richard Allen and just literally do everything that Rossi and Baldwin were going to do and get Richard Allen to agree to that, and that Baldwin and Rossi are right, right there. Right? That's what I would do. You know what's crazy is that, so let me get this straight. During this time, Rossi and Baldwin probably are not allowed to have what you would call, or could they? I don't know what the law is on this. Legal, when they want to meet with their client, are they still considered legal meetings, and they're are these phone calls being recorded? Have they talked to Rossi? Like, has Richard Allen talked to Rossi and Baldwin? And if so, are they being recorded? Does any of that still stand because, all this stuff is going on? Isn't it interesting? Interesting. I don't know the answers, but I have a bunch of questions. And it's just great when Gull says, I gave you the best Allen County public defenders, or the chief public defenders. Neither I, PDC, nor Realtor assert that Realtor's newly appointed counsel, one of whom as the ID is Allen County's chief public defender, is incompetent. It doesn't matter if they're incompetent. They're not going to represent me the way that I want them to, and so therefore I don't have to have them. So they're gone. So they can either withdraw, or I can tell you I'm filing my own motion to say that I want them off my case. That is exactly what can happen. So if I'm Richard Allen, I don't want, no. I would say, hey, is there any chance that can Hennessy represent me? Is it a conflict now because he represented Baldwin? And then that's it. That ends the 22 pages that she filed. Again, it looks really good on paper, unless you kind of break it all down. It looks really good. When I was reading it last night eating sushi, I'm like, oh shit, I need to look up some of this stuff because they're making it seem like that the Supreme Court doesn't have a leg to stand on. Okay. I'm not from Indiana. I have not had the privilege to cover, in the past, any cases. I think the only time I've gone to Indiana is when I've competed in golf at Notre Dame. I pissed on the Golden Dome. Just kidding. We got drunk one night and we were making bets on who could go pee on the Golden Dome. You guys know the Golden Dome's like way up high. Like no one's gonna go pee on the Golden Dome. How was the course? The course was wet. The course was long. The course was newer. But it was cold when we played. It was cold. Looking at this now, guys, this is now the Attorney General for Indiana, Toddy Boy, he wanted to get himself thrown up in this biatch and say, here you go, guys. Here's my response to the realtor Richard Allen's petition for his writ here. And look at this. This is what he cites. At Chambers meeting before the hearing, Judge Gull informed Baldwin and Rossi of her concerns regarding the defense team and the totality of the circumstances. Now, again, he's citing, this is what Gull said, all right? And then he goes ahead. So at Chambers meeting before the hearing, Gull informed Baldwin and Rossi. Then these are the bullet points that the Attorney General wants to make. And let's take a look here. You know that when I was in a member of my country club, I never had the time to get to know a lawyer. I'm sure there was a bunch of lawyers that were members. And that's the one thing I regret is like, why didn't I fucking play golf with these damn attorneys? Wax their asses on the course and bet them in like, hey, you're going to, be my attorney, And so I might just rejoin the country club because I am a badass golfer. Playing some member, outings, the member guest and playing some socials. Ask the pro, hey, can I get a list of the occupations of our members? Who's rocking some law degrees in this bitch? So we might have to do that. Here we go. Improper comments to the public after stating they would not talk about the case. That's not what they said. You guys said, look at this. After stating they would not talk about the case. Like, look at how this language is changing. Like, when did Rossi and Baldwin say they weren't going to talk about the case? They said that they don't want to see this tried in the media. That doesn't mean that they're not going to talk about the case. I mean, do you guys see? I mean, we all know what the Attorney General is, right? They're just, dude, it's like talking to a cop. You're talking to, the popo here. All right. So Baldwin and Rossi issued a press release that was potentially violation of the rule. But was it, motherfucker? Was it? It was potentially. And guess what? We just went through it and it wasn't. All right. It was not. All right. It was not. And at first, I thought the Attorney General would not be backing, Sweet Sugar Tits Gull. But then I got to remember who we're talking about here, the Attorney General in any state. Conflict of interest. Rossi filed a tort claim on Allen's behalf against the DOC. Conflict of interest. Rossi filed a tort claim. Protective order violation. This was what I was saying earlier. Baldwin was negligent and released discovery to Brandon Woodhouse. He did not release discovery to Brandon Woodhouse, okay? But Baldwin negligently released discovery to Brandon Woodhouse, who disseminated it to the public. Baldwin did not alert the court or the state to the release. Now, how would Baldwin know? Like, you guys know when I send out an email, when you guys send out an email, right? I sent out an email. I don't go back and like look through my emails to make sure that I sent it to the right person. Like, that's just not the first thing that I do. I don't go, oh my God, did I accidentally put like the wrong person's name down? You know, so I would love to know, because they said that they did notify, it just wasn't as fast as they wanted them to. But here you got the Attorney General saying that, nope, a protective order violation. This is a protective order violation. Well, what material was actually protected? Because it was an outline of the discovery. So the outline of the discovery, normally what is protected material is actually the material. If we're talking about an outline, I'm just curious. Filing motions with inaccuracies. Dude, this is amazing. I want the Attorney General to write this on my motherfucking behalf. Do you know how many inaccuracies? I mean, holy shit. You know what I want to say right now? And I'm going to be able to say it soon. I'm going to have to keep my mouth shut though. Because I'm going to the Attorney General because of this piece of paper right here. I am going to the Attorney General and I'm going to say, here's this. And now I want you to write the same thing for X, Y, and Z that I'm about to give you that I have on prosecutor and a detective. So what are we going to do about it? We're talking about filing motions with inaccuracies, right? And falsehoods. Okay. Well, every single day, that's all that divorce attorneys do. The pleadings regarding safekeeping Allen in the DOC contain proven false information. Okay, so let me ask you a question. Proven false information. Is there any exhibits with this? I guess I have to go back to June and look at that hearing again and see what they're claiming is actually false information. Versus, was the finder of fact, who is the judge, was that just her determination? Because there's a difference. Like, what do you mean? If you just don't see it as it's enough of a problem, or like, what do you mean that something is, well, basically on the evidence, it was false that you said something that, so Richard Allen saying that he was treated some type of way. What's, I just want to know what the false stuff is. This is just crazy. Protective order violation again. And this is when Baldwin was the source. Baldwin was the source. So Baldwin is now the fucking source of the leak. Baldwin was the source of more leaked discovery. He was stolen from. What in the world are you talking about? Think about it. If somebody steals my gun and somebody shoots somebody, am I going to get charged? Did I do something wrong if somebody came into my house and stole my gun and then shot somebody and they blew off their leg? Am I going to be in trouble? I'm really curious. Well, you knew the person and they knew that you had a safe and that it was, you should have had a different code on there. What? Like, come on, man. But think about how this is changing. This is evolving. That now Baldwin is the source of the leak. I thought the source of the leak was Mitch Westerman. But in this, the Attorney General is saying that Baldwin was the source of more leaked discovery, which spawned a criminal investigation and may have resulted in a suicide. No way. Maybe what the cops said to that man led him to commit suicide. Ever think of that? Kara's limited appearance counsel is now completed. They do not care about the representation of these attorneys. It's so crazy. Just think about that, man. The attorney general is saying that the protective order violation, there's another one, and that Baldwin was the source of more leaked discovery. He was the source of when he wrote out that email. And instead of writing BRAD, when it came up, the first name that it was because he had already emailed Brandon Woodhouse, I'm guessing that he represented him in some capacity, is that he would be in his directory, you know? And see, me personally, I think that maybe Baldwin's just saying that it was him, but it was maybe a staff member, because that's what cool people do. They take the blame for their staff. I'm not going to go throwing somebody under the bus that worked for me. I should have, double checked it or something like that. Who knows? But an email, and boom, now I'm the source. Baldwin is the source of the leak because somebody came in there and stole the shit. And wow. Judge Gull found that Baldwin and Rossi demonstrated gross negligence and incompetence. Yep, she sure did. Gull stated that she did not want to say this in open court, but what if she had to? Judge Gull confirmed that if Baldwin and Rossi did not withdraw, she would remove them. After consulting with Allen, Baldwin and Rossi chose to withdraw. When withdrawing their appearance, Baldwin and Rossi claimed it was unfair because they were forced between being accused of misconduct in open court or withdrawing. I don't believe that's what they were afraid of. Okay? That's not true. Delete any comments that have to do with anybody that's a creator. We don't talk about other channels. We don't talk about creators. Let's see. Only I can do that. When withdrawing their appearances, Baldwin and Rossi claimed it was unfair because they were forced between being accused of misconduct in open court or withdrawing. In open court, without Baldwin and Rossi present, Judge Gull announced that they had withdrawn. Look at this. No, there'd been a big turn of events, right? No turn of events. She had a prepared statement already. Prepared statement. I mean, do you see how the Attorney General is just picking and choosing what he wants to put in this thing? Rossi tendered 2 documents on October 25th, 2023, a notice that he was still Allen's attorney, and a motion to disqualify Judge Gull. Judge Gull took no action on these filings because Rossi was no longer counsel of record. Interesting. So, Baldwin's attorney, David Hennessy, filed a motion to reconsider, claiming that there had been no valid motions to withdraw by appointed counsel. And then on October 27th, Judge Gull appointed 2 new attorneys. So my question is that, so from October 19th to October 27th, Richard Allen was without counsel, right? At a hearing on October 31st, Baldwin and Rossi were present, having tendered appearances the day before. Hennessy also appeared for Baldwin. Baldwin or Rossi did not attempt to present evidence to rebut Judge Gull's factual findings. Key word there. I said it earlier. Factual. She's the finder of fact. Factual findings. finding that nothing had altered the court's concerns about counsel's gross negligence. Judge Gull disqualified Baldwin and Rossi from representing Allen. Hennessy withdrew his appearance that day. No attempt was made to appeal Judge Gull's order. On November 6, 2023, attorneys Kara and Mark Lehman filed a petition for writ of memorandus with the court, asking the court to order the trial court to reinstate attorneys Baldwin and Rossi, to order the trial held within 70 days of granting of the writ. An original action is a limited remedy governed by strict procedural rules. Original actions are viewed with disfavor and may not be used as substitutes for appeals. So they're basically saying that, again, they should have appealed. Appealed what? What do you want me to appeal? Nothing was official. My question is like, I'm appealing what? We didn't have an official hearing. Like, I'm appealing. What do I appeal on October 19th, 2023? How do I go about appealing that? I mean, I don't know the answer. I'm legit asking, but they're making it a point to say, like, hey, you guys did not appeal this. Well, we're not appealing it because we don't believe that it was that nothing truly happened. Like, right, because there was no due process. So, like, how do I go about appealing something that, in my opinion, didn't happen? I do have a question. Can podcasters send some of this info to SC showing that leaks were out before defense came on as like friends of the court? Yeah, that's exactly what actually Rossi said, is that way before we were ever even assigned to this case, there were leaks, and obviously they didn't come from us. So here, let's see. The request that the court reinstate Baldwin and Rossi as Allen's court-appointed attorneys is improper for this writ, and that's number one. A writ, Allen's former attorneys, is not presently warranted. The conditions precedent for a writ are not satisfied, as the claim was not clearly presented to the trial court, and a remedy by appeal is adequate. So basically what they're saying here is that hey, we don't have to do things the right way. Judge Gull doesn't have to do things the right way. But you guys, what you're doing is improper, and you need to go appeal. You didn't appeal this. You should have appealed this. And you're just jumping to the Supreme Court. You are an amazing researcher, her. Thank you, her. I'm going to use that one. Thank you, her. Thank you. Appreciate that. AG is picking and choosing what is official and what is not. They appealed on record in the chamber meeting in reference to moving them. Yeah, if you can take oral freaking withdrawals, then I can say, yeah, no, I'm not okay with this, and this isn't like, I don't. This is how I would look at it. Judge Gull should say, no, bring on these motherfuckers. Like, let them. If Richard Allen wants, I think any way you look at this, how is this not just setting up like an appeal for Richard Allen? I think any way you look at this, like Richard Allen has, I don't care what happens in this case, the first trial. I think Richard Allen's going to have two trials unless he's found innocent, right? Because then it's double jeopardy. So I believe all you're doing here is totally screwing two little girls, and this is going to be a nightmare for years and years to come, and it's just going to cost all of your taxpayers a ton of money, right? Let's see what else. Appeal is both adequate and preferred to review whether a trial court abused its discretion in removing counsel. Okay. leaving them in place as his lawyers opens it up for appeal also. Now I bet you they could probably put some language in on that. Who knows? I think he should be at home when all this is happening, though. Maybe he would have no problem with going to trial, in 2024 if he was out on bond. So Allen did not seek his appeal of either the trial court's order granting withdrawal of counsel or its subsequent order declining to allow counsel to appear pro bono. The record does not indicate that Allen asked his newly appointed counsel to appeal, nor does Realtor explain why original action counsel could not file a limited appearance to seek certification of the court's order, as counsel did to file motions to prepare of this action. So basically, they're like, hey, guys, why didn't you appeal this? Why didn't you appeal? And that's something that I actually learned. Anytime somebody makes a decision, everything's appealable. Your magistrate, anything, boom, just put it on the record that you are appealing. And then just keep asking for continuances, right? That's what they say. No, I'm just kidding. But then I just have to keep going back to what do you want me to appeal, man? You want me to appeal October 19th? I was not, they were not in, when did that order come out? When did the order come out disqualifying them? Because if Baldwin gave his oral withdrawal, it's going to be interesting. It's just... How can anybody appeal anything when there's no official record that stays up, right? Yeah. I don't know, guys, disqualification of counsel can be required, or it can be at the discretion of the trial court. The extraordinary remedy of a writ is not available where the matter is within the discretion of the trial court. An action for mandate cannot be employed to adjudicate and establish a right or to define and impose a duty. I'll tell you what, though, because I think they filed this alone, it would just kick it back that you would just file the appeal. So, though this court has reviewed disqualification of counsel through original actions, the court has not issued a writ to reverse a trial court's discretionary removal of counsel, but has issued writs where counsel's continued representation exceeded statutory authority. Granting writ to disqualify special prosecutor under statute. Granting writ to remove private counsel retained for state agency in violation of statute. So they're listing these cases. But appellate courts have reviewed discretionary removal of counsel through the interlocutory appeal, and removal here was at the discretion of the trial court, so mandamus is inappropriate. So they're basically saying this is inappropriate, and Allen does not identify an absolute duty to reject counsel's withdrawal or to permit them to reinitiate representation. But I thought that he wrote the letter. The law does not place an absolute duty upon courts not to interfere with the attorney-client relationship, but it bars arbitrary and unjustified interference. Allen contends that respondent acted to terminate the attorney-client relationship when she had an absolute duty to refrain from doing so. But Allen does not identify the origin of this absolute duty. Allen's brief does not contain the verbatim statement of the relevant parts of all cases, statutes, and other authorities relied upon, required by the rules. Such a statement is necessary to define the source and scope of the duty that Allen seeks to mandate. A trial court's authority to remove counsel is more announced and less absolute than Allen suggests. Dude, they were just downplaying this whole fucking thing, man. Again, picking and choosing, just the right to choose counsel or continue representation is not absolute. I totally should be drinking Absolute vodka while reading this. Absolute. Woo. But indigent defendants do not have the right to choose appointed counsel. He didn't choose Baldwin and Rossi. Then when the whole shebang happened, then Rossi and Baldwin said that they would appear on his ass pro bono, so he wouldn't be indigent at that point. Oopsies. Oopsies. The United States Supreme Court has not recognized for appointed or retained counsel a distant right to, and the court has rejected a constitutional right to a meaningful relationship with counsel. But the Sixth Amendment's purpose of ensuring a fair trial imposes a baseline requirement of competency on whatever lawyer is chosen or appointed. Platinum Bud Light. The right to choose counsel is not absolute, guys. While the right to select and be represented by one's preferred attorney is comprehended by the Sixth Amendment, the essential aim of that amendment is to guarantee an effective advocate. Well, I don't see how his new attorneys could be possibly an effective advocate, seeing as how I'm not staying in jail or prison, rather, max security, for a year while you guys, pussyfoot around. How can you deem, like... But for retained counsel, courts must recognize a presumption in favor of the defendant's counsel of choice. But for retained counsel, but for retained counsel, court, and they would be considered retained when they were pro bono. That's retained counsel. It's going to be interesting. Indiana has not addressed whether the distinction between retained and appointed counsel alters a court's authority. See, I knew it. To substitute counsel, and authority is mixed in other jurisdictions. I think it changes everything since they said that they were going to represent him pro bono, which is retained private counsel. That's my take from that. That's retained private counsel. It's just crazy is that how somebody, who it's just like you have a referee and the referee could go either way with this. To be honest, I mean, they do it all the time. Just like when you suppress evidence or you don't, go either way. Let's see. The Colorado Supreme Court recently held that indigent defendants have no constitutional right to continued representation by appointed counsel. That's because Colorado's shit. Okay. The Colorado Supreme Court, they would. You know what? They would. That's Colorado for you. There you go. The Colorado Supreme Court recently held that indigent defendants have no constitutional right to continued representation by appointed counsel. But I believe his situation changed once they became pro bono. They were then considered, in my personal opinion, why wouldn't I agree with your points about pro bono and retaining counsel? I just think that that changes the game. This is not an indigent sacrificial lamb anymore, as I like to say. You're at the mercy of the courts here. My gut tells me there is an attorney waiting for the Supreme Court decision to come on pro bono should they not allow. Yeah. I would agree with that. I would agree. I think that there's a ton of attorneys out there that are looking at this case, and you could represent him and be an attorney in frickin' another state. Okay. You're going to be able to, no, they don't work for the state. They were private practicing attorneys. That's the other thing is that, no. The court found that any right to continue of counsel must flow from the right to choose counsel, which indigent defendants lack. See, but he is not. This, in my personal opinion, this argument right here is going to fail because this does not apply to him. But the court recognized that indigent defendants have an interest in continued representation by appointed counsel if they can demonstrate that prejudice would result from substitution with a different court-appointed attorney. And I think prejudice would result because he wouldn't go to trial in January of 2024 when that's when he needs to in order to not be prejudiced, in my opinion, or biased. And that's how I would do. That's how I would say that. You know, by me having a substitute, I'm going to be prejudiced because I can't begin my trial in January of 2024, which is my right to a speedy trial. So you're fucking up that. And so I think that that's going to prevail, that argument. I mean, how can you deny him the right to go to trial in January of 2024? Again, if you do, you're going to lose the appeal. How do you... Trial courts must give great weight. Again, these are people, what we're reading here is these are different cases and those decisions. The trial court must give great weight to a defendant's preference, whether requiring a presumption of weighty consideration. Trial courts must weigh a defendant's preference for representation against the circumstances favoring disqualification. Yeah, indigent is, he's considered indigent. Whenever you have a public defender, you're considered indigent. Oh, yeah, you need to represent I can choose to fire my lawyer at any time and withdraw my indigent status and hire a different lawyer. Yes, you can. That's why What's Her Tits asked. Gull asked in the chambers, and she says, well, I'm assuming that Mr. Allen's indigent status hasn't changed, right? And that he's, she asked that for a reason. I'm telling you, she's not a dummy. Gull is definitely not a dummy. She's a sneaky bee, okay? Sneaky bees, they're not dummies. They're just sneaky bitches. She's a sneaky bitch. She knows the fucking laws. If you know the laws, that's like knowledge is power. You can tippy-toe around things if you know how you can, do it. You can, hey, I know that if we just can't take it too far, we can do this and we can still skate around this and we can say this. She knows what she's doing. She knew what she's doing. She's the one that had all this time to prepare for what she was doing. And she looked up stuff and knew. That's this is all my opinion. Okay. But I think that Richard Allen, once he had pro bono representation and that's considered being retained, he has his own attorneys, and to disqualify them, when she went ahead to disqualify them on October 31st, I don't know how she can do that. That would be my, the right to counsel must be balanced with the need for a fair trial. Contrary to Allen's claims, more than two circumstances may require a court to interfere with a defendant's preference for counsel. As Allen recognizes, but here they're basically saying that, no, we disqualified them because of, so did you disqualify them from that we don't work for the public defender's office anymore? But what if Allen wants us? Contrary to Allen's claims, more than two circumstances may require a court. It may. Not that it has to happen, but it may require a court to interfere with a defendant's preference for counsel. As Allen recognizes, a defendant cannot insist upon counsel who is not admitted to practice. And a court may act to remove counsel when the representation creates an actual or serious potential for a conflict of interest, including refusing to permit the defendant to waive the conflict. Okay, so then since Rosie was the one that filed for this civil proceeding, Baldwin didn't do it, so we can have Baldwin. How about you just stay the fuck out of it and none of this should have ever happened. You know what I mean? They act like what was leaked, y'all. This is, everything that has been leaked, because I agree with Rossi, he's like, I don't care. He's like, this stuff is coming out in court. This is not stuff that's not going to come out. So what are we really talking about here? There's no leaks. These are things that are going to be seen, by everyone and anyone. And we're talking about when Mitch Westerman's only being charged with a misdemeanor, that's the other thing. Is if this was so bad, then why is Mitch Westerman, and then why isn't Baldwin being charged with a criminal? If he is the source of the leak, then why wasn't Baldwin arrested and charged with a misdemeanor? Oh, Lana, because he didn't do he's just the source of the leak. What? No, you're basically saying he's responsible. He's responsible. So why wasn't Baldwin arrested? Why wasn't Baldwin charged? Don't you think Baldwin should be charged? I don't know. I just think that you just can't have it both ways. Where are we at here? Counsel says, serious potential for blah, blah, blah. Counsel conduct of personal circumstances may justify removal, gross incompetence, or physical or misconduct. So there you go. Interesting. Yeah. So here we go. Where was there a citation for contempt? Because if you violated the protective order, you're in contempt. Why didn't the prosecution file a motion for contempt upon the defense? Why didn't they try to put Rossi or Baldwin in contempt? Once you file a motion for contempt, you violated the court order of a protective order that you were part of this leak. So that's a violation of the protective order. So therefore we're going to file a motion for, to have you, to hold you in contempt. Think about that. What's up, Sleuthy Goosey? How are you? Exactly, because Nikki Boy was up Morning Night investigating, man. He was running the show. He's like, I am up here investigating because my investigator is clearly below. So I was investigating. Yeah, why didn't they file a motion to disqualify? Why? I mean, I don't know how you appeal something when there's no. I mean, how can I even appeal something that happens in chambers, and then I'm not present for on the 19th, and I don't think that Baldwin or Rossi would have to be the ones that would be filing that, because if they weren't his representation, then it would have to come from the new attorneys. So does that make them incompetent that they didn't file the appeal? So his new attorneys become incompetent. But Baldwin's responsible for a suicide. No, I think the cops that talked to the guy and probably harassed the shit out of him and threatened him and said, yada come yada. Whatever. Just craziness. And a defendant may not insist on the counsel of an attorney who has a previous or ongoing relationship with an opposing party, even when the opposing party. No shit. The need for effective administration of justice may require removal. Well, either way, you guys are going to be trying this case again. So congratulations. It's my professional opinion. Courts must also balance the need of the public and victims. Really, because you finally talk about the victims. That's the first time you've talked about the victims. The general public and the victims of crime also have an interest in the even-handed administration of justice. Trial courts have the discretion to balance these interests with the defendant's desire to be represented by his preferred counsel. Though varied interests may necessitate overriding a defendant's preference, disqualification is an extreme remedy that should only be used when a court deems it reasonably necessary to ensure the integrity of the fact-finding process, the fairness or appearance of fairness of trial. So maybe we're not going to be fair, but we just want to appear fair. Just love their fucking wording, man. Oh, I cannot wait to call up my attorney general and say, hey, I got a question for you. I would like to file a complaint. Oh, shit. Kay Miller making everybody green today. Look at that. Look at that language right there, guys. This is just typical fucking law language right here. We are just going to appear. So the fairness or the appearance of fairness. Guys, we just have to appear to be fair, okay? You got to love it, man. Bunch of fucking idiots. You know what's crazy is I would party with lawyers. I'd hang out with lawyers. I'd play golf with lawyers. But I don't want a lawyer. Because I don't trust you. Because at the end of the day, I mean, God, but it would be so hard because I would totally want somebody like Baldwin. I mean, both of them. Rossi totally stuck up for Baldwin. I mean, it was just crazy. The lack of record prevents review of counsel's disqualification. Defense counsels withdraw the proceedings in the present record prohibit complete review of whether the trial court's concerns justified substitution of counsel. Oh, get out. Now we're going to blame the defense again because they decided to withdraw. And it totally then messed up from us getting a complete review of whether the trial court... I cannot. Are you kidding me? In chambers prior to the October 19th hearing, the court listed reasons it felt counsel should be disqualified that it intended to address in the hearing. Really, because that's not what they said at all. The prepared statement was just that what? Let me just shoot my head right now. I cannot believe what I'm reading right now. The lack of record prevents review of counsel's disqualification. The lack of record. What record do y'all want? Because they were threatened to either be publicly shamed or withdraw, and the public shaming means that it's going to hurt my client. I don't want any negativity, on him, so we can't go that route. But if we would have just went that route and we would have let a record stand, so does that mean everything in chambers? I mean, there is a record of it. It was recorded. Read it, motherfucker. You're citing it. It just, I have no words. The lack of record. There's a 136-page Frank's motion, okay? Go read the 136 pages, all right? Number one. Then go check out the 1,300 pages of the exhibits, because Gull says there's 1,500 pages that make up that. Get out, man. Get out of here. Where is the paper trail that there was going to be a hearing about it that day? Yeah. All she had was a prepared statement. You guys saw what she said when she came out there. The cameras were all out there. Remember that too? She said when did she agree to allow the cameras to be there? Does anybody know that date? That date's probably really important. What date did she allow cameras? I'm going to have to look that up. When did she say that was like what? We're going to allow cameras. We have cameras in here. What date were cameras decided? For the 1019 hearing. So whatever date she decided to let the cameras in, I think that should be looked at. Boom. But this hearing did not occur because defense counsel withdrew rather than challenge the factual. How can I challenge something? They were saying that. Was that same day, I believe. They said it the same day, you think, critical thinking? I usually have to motion. There would be a motion put in for the cameras. So I'll double check all that. Wait, I need to read this again. I'm gonna need another Jameson. Let me see if this is what I'm reading here. The prosecutor was prepared to present evidence. Oh, Nikki, but you ain't prepared for a trial, but you're prepared for this. And then you're going to whine like a little bitch and say, I'm not prepared for trial because I've been investigating this leak. That's not your job. I don't care. Cry all you want. Why are you doing your other people's jobs in your fucking department? Defense counsel withdraw. It was totally the reason that we do not have the record, the lack of record. In chambers, prior to the October 19th hearing, the court listed reasons it felt counsel should be disqualified that it intended to address in the hearing. So are you referring to the phone call that took place? Because nothing took place in chambers before October 19th. There was emails and there was a phone call. So what is this? What are you talking about? Who was in this in chambers prior to that? What, the judge was just talking to herself in chambers? I mean, what are you talking about? There was emails and there was a phone call. The prosecutor was prepared to present evidence, or just so they say. The prosecutor was prepared to present evidence from the leak. That's just because that's what he said. What evidence are you going to What evidence is there in the leak? Baldwin already fucking told y'all, and Rossi told you how the leak happened. What evidence are you bringing to the table? Yeah. That's and it was actually Rossi that asked to, like, have even a meeting, have even like, hey, so what's going on with this thing? Like, if he doesn't email and like make some, hey, what's up? It's frustrating. Yeah, her and Judge together. Haha. Yep, right there. No. The prosecutor was prepared to present evidence from the leak. You guys, but what evidence from the leak? What are you prepared to? You guys think about this. Rossi and Baldwin told, it's like, here, I'm providing the courts with exactly how this happened. Hey, Mitch Westerman came into my office, took pictures, and yada come yada yada. So there is no, hey, we have all this evidence that we're going to present of what we told you happened. That's what you've been losing sleep over, Nick? Okay. And you want me to present evidence that says what? You want me to have my geofencing? You want me to call in an expert witness to show where I was located at the time when Mitch Westerman came in and stole it? So my evidence would be like, okay, do an affidavit of Mitch Westerman saying that I had no idea about it. I should have had Mr. Westerman there as a witness to talk on the stand that day. What could have made this any more clear as to the prosecution was prepared to present evidence? What evidence from the leak? We already know what happened. There's nothing what are you talking about? Can this is coming from an attorney general. Like, he is writing this shit, man. I'm blown. I mean, I'm literally like stunned that you're going to say this. But the prosecutor was prepared. But guess what? He's not prepared for trial, though. But he's not prepared for double murder. But double murder, he has no idea what he's doing. He's crying about that. It's a good thing that he can investigate a leak that didn't need investigating because the defense team told you guys how it all transpired. But we should have evidence presented to be able to combat what? That Baldwin wasn't in the room when the items from Mitch Westerman were taken pictures of. And Mitch Westerman are like, if you investigate, then you know that Mitch Westerman already said that Baldwin wasn't in there. I mean, but this hearing did not occur because defense counsel was a bunch of pussies, they're basically saying. Withdrew rather than challenge the factual allegations. How are you calling them factual allegations? Allegations, then you would just say rather than challenge the allegations. Look at this, the factual allegations at the time. How do you know that they're factual? This is unfucking believable. This is disgusting, actually. Cheers to Indiana, man. That's another place I wouldn't live. Get me out of Colorado, Idaho. I mean, did you read what they said, though, why Rossi is in trouble or why Rossi's part of it? Because he knew that it was the command room. And he knew that Westerman would drop by his office, and he knew. I can't even believe this shit. That cannot be factual at a hearing. Who can write this? But this hearing did not occur because defense counsel withdrew. Rather than challenge the factual allegations. No, they would just be called allegations, sir, at the time. You see allegations at the time, but they're factual allegations. Suck my tit. The left one. My right one gets enough. At the October 31st hearing where Baldwin and Rossi attempted to appear for Allen and their own counsel, no additional evidence was offered or arguments made to rebut the court's allegations. What allegations? What allegations? Where was this ever done in any formal way that there was an opportunity to truly have this, like, okay, we're going to have a hearing. We're going to have a hearing for the leak. Wait, but isn't that what Rossi was saying in the freaking chamber? Do you want to have a hearing for this? Shouldn't we? We should have a hearing. We should have due process. That's what they were asking for. So the attorney general is literally taking the transcripts from the chambers and literally just lying. You're fucking lying, dude. You are picking and choosing what the fuck you want to put in your little fucking lack of the record C section here, okay? And you're wrong. This is absolutely craziness right here, because that's exactly what Rossi and Baldwin were saying in chambers was due process. We want a hearing. But why wouldn't we have a hearing? I don't know if we need a hearing for this, but I don't know if it's, everybody should be seeing this. I don't know what you want to do with this. But they most certainly wanted to be prepared. And I object to all of it, even the word challenge. How could they possibly challenge anything, factual or not? They were saying it in there. They're saying that this is not right. What transcripts was the attorney general reading? Okay. Are you blind? Do you need an interpreter? Because I have Tina with What the Fuck Translation Services, and she's one hell of an interpreter. This is just unbelievable. Look at, he's citing this. Well, why aren't you citing everything that Rossi and Baldwin were saying in chambers? Unreal. Respondent raised concerns that could warrant disqualification depending on the circumstances. The court's concerns raised questions regarding counsel's compliance with professional ethics and ability to provide Allen effective representation. After the state sought a gag order, counsel had assured the court they did not intend to try the case in the media, but then assured a detailed press release challenging specific evidence that the court believed violated professional codes. That's not even in the right order. This isn't even in the right order. He didn't read them, silly duck, says Sleuth Goosey. You're the only duck I see, Goosey. Tina's the queen. This is Tina with What the Fuck Translation Services, and I'm curious to know this order. Actually, it goes right to here. Right here. The restriction on publicly commenting on specific evidence. You guys, they said our client is innocent and they're getting reprimanded. Like, this is unheard of. What was the extrajudicial statements? Because I can't even. I'm going to have to go have some more sushi, because this is just, Lana, get your groove on. This is ridiculous. He got no time for reading. I cannot wait to have a field day. I'm going to Indiana, man. Oh, I need a driver. Tina. I just want to stand out in the courtroom just to get tossed one time and say, The fuck? This is Tina with What the Fuck Translation Services. And what the fuck are you guys talking about in here? I'll just see myself out. Thank you. You guys, our client is innocent. We've talked to Rick. He said he's innocent. Hey, journalists, this is now your time to be journalists. You're disqualified. I can't, man. Oh, man. Don't worry, Your Honor, I'm going to see myself out. JLR is going to yell from outside, but I'm going to go in the courtroom and I'm going to be like, what the? This is Tina. You guys. Oh, man. How dare you tell the world that Richard Allen is innocent, man? But it's okay with you guys saying that Richard Allen is so guilty, because I thought that the United States of America, you were innocent until proven guilty. So how is that extrajudicial statements? Our Constitution says it for us. God, I fucking can't stand. You guys, please start voting. Please start voting for people that are shitbags, okay? Because stop voting for people that are out there acting like they are the amazing people. Start voting, I'm telling you, for shitbags, okay? Shitbags are at least telling us the truth that they're shit, okay? I would rather be told to my face than me think that I'm, voting for, the Virgin Mary. Get out there and vote for shitbags, man. Get out there and vote for shittiness, okay? Because, these people that act like they're feeding the homeless and if they give a shit about single, Black women and, their 5 kids, they're lying, okay? They're all full of shit, especially in these Midwest states. They are all racist, and trust me, they don't give a fuck. But go out there and vote for shitbags, okay? At least you know that they're shitty. But this, why go get let down? Come on, Indiana. Ridiculous. The court expressed concerns about counsel's candor. Candor. Baldwin informed no one that a defense outline had been sent to a third party for months until the state discovered it. Why did the state take months to discover it? Oh, because they're fucking shit. You guys, read that sentence, man. Can I ask a question? Why did it take the state so long to discover that? It took them months to discover that? Well, I'm sure, look at this. Where is it? Right here. Yeah. Sent to a third party for months until the state discovered it. Well, I just think you're outing the fact that you guys couldn't fucking, figure it out for months. So I think that's more on your guys' end. But how can Baldwin inform somebody of something that if he doesn't know about it? I cannot repeat this enough, guys. When I go and send emails to people, I don't go back and check my emails and say, okay, who did I send that email to? No, I just think that I sent it to the right person. Normally what happens is that if I sent it to the wrong person, somebody's emailing me saying, what the fuck are you sending me? And I'm like, oh God. Or if I'm expecting a return email and then days go by and I'm like, yo, have you checked the email that I wrote you? And they're like, what email? And then I go back and check and I'll be like, God, how did this not send? And then sometimes I still won't see that I sent it to the wrong person. I'll just resend what I was supposed to send. So how can Baldwin, I don't know what I don't know. I can't tell you that I sent this to some him-ho fucking woodwork dude, turn them all green. Kay Miller's like, I'm turning all of you guys green. And that does not mean that you guys need to recycle more. That means that you guys just get to bypass any of the slow speed and get to hear some amazing content tonight. Bella's going to be joining me, and we are talking about the Molly Tibbetts case. If you are a member, you get to hear this members only, where I blow out of the water because I believe that the Molly Tibbetts killer is still out there. And I'm going to fight for a female that is the wife of the accused and convicted killer. She, a Mexican woman, well, half Mexican. I'm just going to tell her, let me take a look at something because his defense team just sucked donkey balls. But But yeah, K Miller slam. I'm not green. I know, but at least here at Truth and Transparency and on YouTube, we are not biased and we are not prejudiced. YouTube picks you get a membership or not. I am not biased or prejudiced. YouTube is prejudiced or biased. So take that up with fucking YouTube. But the more that you comment, that's how you can get yourself. The more that you watch, your watch hours, your comments, that's how you get them. That's how they pick, as far as what I was told. So if you're lurking a lot in my channel and you end up with a membership, we get to see that and then we laugh about it. We go to sushi and we just fucking die. We're like, oh, did you see you got a membership? That fucking troll watches me 24/7. They fucking got a membership. So I just get a kick out of that because I can't see it on my end until I go back and watch the show, which I hardly ever do. But I started to do it once the gifting started because I wanted to see who was, winning the memberships. And so we would go back and watch, and then I just laugh. I'm like, look at you getting caught watching me. But you hate me. You hate watch me. You know what hate is? Hate is love, just in a very, very weird way. You should request some body cam footage from the town of Delphi to check. I don't even know if they have body cam, man. I swear. I think the only thing that's good about Indiana is that I don't live there. So just kidding. You guys, I live right next to Indiana. Actually, my uncle was the president of the big old university in Indiana. So look out. And I didn't even want to go there. I don't want to be a Hoosier. I want to be a Bearcat. I want to live in the ghetto. Just kidding. Oh, I didn't want to be a prepster. You guys, I can't even finish this shit. I need another Jameson. I just can't even. I want to go eat sushi, and this is just embarrassing. This is embarrassing. This is totally taking away. Like 2 girls were murdered, and this is what's happening. And this is what Indiana's allowing to happen. And it's a shame, I am from Indiana and live here. Yay, see? There you go. Indiana's my neighbor. Lana, I need you to say the word baby doll. Doll. Lana, I live in South Bend. Oh, good. I played golf there. Yep. A lot of my family were Irish, so we root for Notre Dame. I mean, I root for Notre Dame as long as they're not playing one of my teams. So there was nothing to do. Like, I just felt like the campus was kind of boring. I dated a guy that went to Indiana, or not Indiana, but Notre Dame. He was really smart. Picture there. And I'm like, God, like, I don't know. He loved it, but I just felt like it was boring. I'm a city girl. Wishing all of our trolls a happy Thanksgiving, Christmas. Yeah, there you go. Yep, Bella's in the background there somewhere. Bella, do you want to have some Jameson?
Yeah, what? You need one?
Yeah, I'll just have a little one. I'm going to end this out. I'm going to round this out.
Are we going to go eat right now?
Yeah, we're going to get some sushi. You want some sushi?
No, let's just do chicken.
Do you just want chicken?
No. Give me your thing. I'll refresh it.
Oh, here. Thanks. What a doll. Yeah. LOL, I lurk, but I'm not a troll. Oh, that's good. I mess with people. I want everybody to feel welcome to. Some people don't even know that they can chat. I got people that watch on their TV all the time, and they're like, Lana, who are you talking to when you say these names? Like, who's Miss Kelly? Who's J Funk? Who's Danny? And so I try to do a good job of, if I say your name, that I show what you're writing. And then I have to explain to them, like, yeah, you see that comment right there? Like, that's somebody that's writing in that live chat feature. But they don't, they're older and they don't know what I'm even saying. They think I just talk to myself, which I do. But yeah, so they watch on their TV. But guys, this is just, if you just read this, you'd be like, oh yeah, they have a great argument. counsel's conduct could implicate a conflict of interest or endanger Allen's ability to secure an impartial jury. You know, like that's what's crazy is an impartial jury.
In what county?
How is Richard Allen supposed to get a fair trial when everybody thinks he's Bridgeman and that Bridgeman is the killer of 2 girls? But yet the real witnesses, okay, they are saying complete opposite things of the PCA. So that PCA is what scored Richard Allen in a possibly an impartial jury. It started with that PCA that was public. That PCA went public. That is what made the world think that Richard Allen is a fucking little pedophile freak killer. Right? Oh my God, look at his social media. He was taking pictures of his daughter at that bridge. And then he went and killed those girls at that bridge. You know, it just, but you have the audacity to write this, that counsel's conduct. No, they're trying to save this man's life, dude. And I just think it's a shame that you can literally, I'm embarrassed. Like, I would never write this. This to me is like bitch ass shit. Like I would never write this. I would never write this shit. Like that's embarrassing, man. Who owns your nuts, Todd? What's your name? What's his name? What's this dude's name? Yeah, there you go, Todd. Todd Rokikida. There you go, Todd. Todd, who owns your nut sack? All right. Because I'm going to change a song for you. It's called Roasting. What is it? Nuts Roasting Over the Santa's Fireplace. What is that called? Mm-hmm. Chestnuts roasting. Todd's nuts roasting on Gull's. Her chin, probably. You know?
Can we cheers, though?
Yeah, cheers.
To what?
Cheers to Todd being a sack.
No. Cheers to Baldwin and Rossi being bad.
Yeah, Baldwin, Rossi. Boo. Chestnuts roasting Todd's balls over Gull's chin. Don't worry, give me some time. I'll come up with a nice, I'll change the lyrics up. I'll do a holiday special. Sweet Lord have mercy. At least you guys come here for good laughs, right? You're like, Lana doesn't know shit about true crime, but I go there for the laughs. That's what I get told all the time by my cop friends. They're like, you don't know procedure. I'm like, you don't know dick. Anyways, this is just, you know, I'm gravely concerned for Indiana. Oh, by the way, defense counsel permitted 2 separate leaks of protected material, including graphic crime scene images. Public dissemination of graphic crime scene images could inflame prejudice against Allen. The crime scene is going to prejudice Allen?
But I mean, isn't that saying the thing that we've all been saying from the beginning is why would the defense want to leak crime scene photos?
You don't make any sense. But that's their take, though, is to try to say, like, yeah, you're getting horrible representation because your lawyers are fucking this up for you. No, the only people that are fighting for Richard Allen, and the only reason that now the community at large and in the public believe in this man's innocence, not because our Constitution tells us to think that way, is because of these 2 gentlemen. Otherwise, everybody out there would be saying that he's a killer.
But this gives props to Furnessy and Click, and Furnessy got killed by somebody who worked for the prison system.
But we would have never known about it had they not put it out.
100%.
Like,
there's good cops out there that do their
there's amazing cops out there. You guys, you only hear about the shitbags because it's, you know, not that many. Look at the news. They don't talk about anything good except when they want to do around the holidays. They're like, oh, this person gave away some food. You know, that's the media just trying to do pat their own backs like they give a shit. Anyways, like I said, I'll argue with the best of them. Lana, when that man gonna get he gonna be on your panel? What man? cracking up at work. That's how we do it. Jingle gulls, jingle all the way. Oh, what fun to suck on Todd's balls in a one-horse open sleigh. Hey. Yeah, it looks good on paper until you dissect it. It's lies.
No, but it looks great, and it looks like if you don't know the case, that she has the best interest of Richard Allen. They all have the best interest of Richard Allen. If you know the case, you know that what they're saying is a complete fallacy.
Mm-hmm.
That she has hidden documents from the case record.
Yeah.
She hasn't even ruled on Franks.
Yeah, she hasn't even ruled on Franks because she ain't got enough time. She said, I don't know. She should have had plenty of time having her ass all held up in she's in the hospital.
Well,
So she should do lots of reading. You guys, I read 732 pages last night in what would I take, Bella? Like maybe an hour? Maybe an hour.
You might have taken a little bit more than an hour. That's because I was bugging you a little bit.
Yeah. So if you guys ever want a speed reader, But yeah, join me back here, Molly Tibbetts. I'm actually gonna start that at 9:30. 9:30, not 9. Eastern time. Me and the link has already been posted in the members community section. So Kristen just went ahead and hooked like, I don't even know, 50 of you guys up today, 60. Wow. Look at Gifted. Like she's such a doubt. Kristen, I'm gonna buy you a Truth and Transparency hoodie that says membership giving bitch. Comma bitch. Yo, bitch, I got your membership. No, she's been spraying people with memberships, and
everyone's green.
I just love it. I think it's great. I'll come up with something cute. Just let me know your size, and if you don't want to give out your size in chat, send me an email. Otherwise, I'll just make it an extra small. I'm kidding. All right, guys, take care till next time. Like I said, we believe here at Truth and Transparency, innocent until proven guilty. We try to see both sides. We try to be fair. And most importantly, we try to be funny. This is Tina with What the Fuck Translation Services.
Oh my gosh, I missed translations with Tina.
Yeah. Thank you for, Goosey got one. She must lurk a lot. I got Sleuthy, we'll have to do a live here soon. We can go ham on mainstream media. You know what I'm saying? Let's pound on a little bit of mainstream media. Actually, I want to put together a timeline, and maybe you want to be part of it. I'm putting together a nice little timeline of with the the Jared Bridegan Gardner case. So, all right, guys, until next time, stay warm, snuggle up. See you soon.